So, the consumer welfare standard is dead. The consumer welfare standard was a product of neoliberal ideology. The consumer welfare standard is slanted against enforcement. The consumer welfare standard is, at the end, it's a failed experiment. These are some of the statements which I'm sure you've all heard in the past couple of years, probably more than once, maybe even twice. How much substance is behind these statements and how much is a slogan? Substance is defined as the essential nature of something. It comes from the Latin substare, which means standing firm. Slogan, on the other hand, is defined as a memorable phrase used to express an idea, persuade, and often call to action. It comes from the Old Scottish, and it means army shout. In other words, it's a battle cry. Substance deals with the true nature of things. Slogans are a rhetorical device. To set the record straight on the substance and the slogans of consumer welfare standard, I'm joined today by a stellar panel of speakers. Dennis Carlton is professor of economics at the Graduate School of Business at the University of Chicago. Kenneth Elzinga is a Robert C. Taylor professor of economics at the University of Virginia. Cani Fernandez, joining us online, hello Cani, is the president of the Spanish CNMC. Herbert Hovenkamp is James G. Dinnan Professor at the University of Pennsylvania Law School and the Wharton School of the University of Pennsylvania. Fred Jenny is Emeritus Professor of Economics at ESSEC and until very recently indeed, Chairman of the OECD Competition Committee. Now we'll kick off this 1-hour panel with a presentation by Professors Hovenkamp and Elzinga. Professor Hovenkamp will speak about what the Supreme Court has said about the goals of antitrust. Professor Elzinga, in turn, is going to talk about what the critics of the consumer welfare standard really ultimately seek to achieve with their critiques. After that, our panelists will discuss some of the most prominent statements about the consumer welfare standard and try to separate slogans from substance. Just so you know, this is meant to be a back and forth, more free-flowing conversation rather than a series of presentations. Professor Hovenkamp, the floor is yours.
Thank you. Is there a clicker for the slides?
Yeah, sorry.
Thanks. Those are Ken's. Thank you. Okay. I believe, I'm speaking about U.S. antitrust law, I believe it's had a pretty solid metric ever since the Sherman and Clayton Acts were first passed. Whether we want to call it welfare, that's a question that we can dispute a little bit. But the three goals of antitrust ever since the 1890s in the United States have been combating practices that increase price, that reduce market output, or that hinder innovation. Price is the thing that lay people probably think of most often. They don't make complaints that the output of eggs is too low. No, they complain that the price of eggs is too high. On the other hand, output is used somewhat more frequently by economists as an essential metric for the examination of anti-competitive effects and even welfare. Impact on innovation is the most difficult thing to measure, but it is necessary that it be measured in some cases. And what I'm going to try to show is that the US courts have stated these goals pretty consistently ever since the 1890s. The agencies have not been so consistent. And then finally, output and welfare, consumer welfare, move in the same direction the great majority of cases. It is possible to model certain cases in which output goes up and welfare goes down, or vice versa. They usually have to do with things like price discrimination, or Fred Scheer 30 years ago modeled a situation in which vertical restraints divide marginal and inframarginal customers, and you could also show higher output and lower welfare in those circumstances. The thing is, to the best of my knowledge, no US court has ever found that output and welfare move in opposite directions in any given case. So whether these situations are more than just little talking points is for us to think about, but certainly not very important. But looking at antitrust goals, like I say, these are all from the Supreme Court. Court has been pretty consistent that restraints of trade are associated with higher prices. If you look at U.S. versus Standard Oil, this is the big Standard Oil case that was decided in 1911. The indictment in that case alleged that the defendants limited the production, output, and markets for petroleum. The International Harvester case, that's another Section 2 monopolization case, that the purpose of undue restraints of trade is to prevent unreasonably high prices. The IBM, that's the International Business Machines case of 1936. That was a case that condemned a tying arrangement under Section 3 of the Clayton Act, citing as the anti-competitive harm overcharges for the paper data cards. The cards that IBM sold under that tying arrangement were too expensive. That started a 40 or 50-year long debate about whether tying harm consisted in overcharges in the tied product alone or some combination of the tying and tied product, or foreclosure, which was also raised in that case. U.S. versus Continental Can, that's a Section 7, Clayton Section 7 merger case. Now there's a little bit of history here. 1962, the Supreme Court decided Brown Shoe, a very, very severe outlier in the history of antitrust that actually identified lower prices with merger harm. Immediately, the Supreme Court corrected itself in 3 decisions over a 2-year period. Those were Philadelphia Bank in 1963, Continental Can, which I put up on this slide, in 64, and El Paso Natural Gas, also in 1964. And what all 3 of those decisions did was basically right the boat by identifying merger harm with higher prices. Fortner, this is Fortner 1 in 1969, first gave us a more formal definition of market power as the ability to restrict market output in order to raise price. And then finally in 1979, in Ryder versus Sonaton, we get the Supreme Court's first use of the term consumer welfare. Up till that time, the courts never spoke about welfare. There's no evidence that the framers of either the Sherman Act or the Clayton Act, Supreme Court justices knew anything about welfare economics. Of course, by the time the antitrust laws had been passed, Pareto had written. Pagoo was just starting his career writing. But practically all of the big writers on welfare economics, Calder, Hicks, Harburger, Arrow, none of them had been writing about had written yet. And so antitrust was very largely innocent of anything that had to do with formal economic welfare. Ryder used the term consumer welfare only to speak about the fact that consumers would be injured when the price, in this case of hearing aids, was increased. So that leaves this question, this nice question, well, then what did consumer welfare change when the Supreme Court introduced it in 1979? And I think the answer is not a damn thing. The next big case, Pacific Stationery in 1985, identified the harms coming from an antitrust violation as restriction of competition and decreased output. And then the last 2 are the 2 most recent Supreme Court decisions. Amex, which identified the target as reduced output, increased prices, or decreased quality. And then NCAA versus Alston just a couple of years ago on the effects on competition, quote, especially its capacity to reduce output and increase price. And so the metrics that the court uses are really not related to welfare. Now there's lots and lots of economic reports, expert reports, that draw welfare conclusions, although in virtually all of those, the principal variable used to determine a welfare result is either a change in output or less frequently a change in price. And so the metrics the court uses are clearly are solid. They're related to three observable things, not always necessarily easy to measure, but they are related, in fact, to price, output, and innovation. Interestingly, these are all recent complaints. Even the Biden administration, when it wanted to win cases, cited these same factors. So the most recent big tech complaint is US versus Apple, which speaks about the relationship between Apple's practices and lower prices, higher output, improved innovation, or a better user experience. The complaint against Amazon and Washington FTC complaint speaks about the distortion of markets by blocking off avenues of competition, including price, product selection, and innovation. And then the Facebook complaint, which was the first complaint was actually brought in the Trump administration. The amended complaint during the Biden administration also spoke of higher advertising prices, increased choice, quality, innovation, and so on. So what I gather from that is that the term welfare or the term consumer welfare really does not add a great deal to what it is that antitrust courts in the United States are attempting to measure, because in most of the cases, in fact, virtually all of the cases, what the court is really measuring, estimating, is impact on price, impact on output, or impact on innovation. And at most, consumer welfare becomes a kind of short way of stating those three things without actually measuring things like the amount of consumer surplus. Like I say, there are plenty of expert reports that do that, but it has not been an essential factor in the way that the courts measure. I should add, there are 100 Supreme Court decisions that make statements of this kind. I've just picked out, I'm sorry, I gotta figure out how to go back now. Oh, okay. So what changed? Well, I think formally nothing changed. We measured things the same way. I think one thing that happened, and I don't think it can be related to the introduction of the idea of consumer welfare, is that certain outliers were brought back into the fold during the 1970s and 80s. For example, the law of vertical restraints, particularly under Schwen and Albrecht, became completely disassociated from impact on price or impact on output, and they were pulled back into the rule of reason. The rejection of brown shoe, which I just talked about, brought merger law back into a regime that was concerned mainly with higher prices and lower output. And then a quite elaborate series of decisions by the US Supreme Court in the 1970s, beginning with gypsum, US gypsum, that tried to make the goals of the Robinson-Patman Act more consistent with the goals of the Sherman Act. And the way to do that was to try to identify circumstances where the practice called price discrimination under the Robinson-Patman Act actually had a competitively harmful impact with the harm measured by price and output. Thank you.
Herb, are you able to put my slide back up? Or
I can ask. Can we put Ken's slides back up?
I just need the one with I have one slide with a picture of Post
okay. I don't want
and
that.
Smith.
Thank you.
There we go.
I think they're up.
Oh, no, that's
not yet.
Well, in the meantime, while we put the slides, I think we already have two slogans to discuss, perhaps after. One is the consumer welfare standard is dead, and you're suggesting that this administration,
Next one.
the outgoing one, which is staffed by some prominent neo-Bendesians, has actually used and has won many cases based on that standard, right? So that would question the narrative that the consumer welfare standard is dead. If you want to win cases, you have to rely on it. And again, we can discuss that after Ken's presentation. The other one being that the consumer welfare standard is a Chicagoan or a neoliberal plant. You're saying that the DNA was there since the beginning?
I'm saying something stronger than that. I'm saying it really hasn't changed at all.
So we just gave it another name? What changed?
I don't even know that we gave it, you know, the words consumer welfare have only been used in 7 Supreme Court decisions.
Right. Is it a slogan then?
Well, I'm not sure I'm prepared to answer that.
Okay.
The courts are consistent that the goal of the antitrust laws is to combat higher prices, lower market output, or restraints on innovation.
Okay.
And if all you want to say is that is what consumer welfare is, then they're adopting the consumer welfare standard. If you think it is something else, particularly things related to the metrics of consumer surplus, which judges don't like to measure, then I don't think what we're doing is consumer welfare.
Let's put a pin in that, get back to it, but let's give Ken 8 minutes for his presentation.
8 minutes. Could I have my next slide up, please? Thank you. I'm going to ask you to engage in some multitasking. I'm not going to read the slide or really refer to it. I'll ask you to read it in the context of my remarks, because I take as my text the Gospel according to Adam Smith and Ronald Coase. And I don't have time to read the quotes. I'd ask you to read them while I speak. But from Smith, we have the principle of specialization and division of labor. And that explains a great deal about how wealth is created, and it warns us about the folly of mission drift. Stick to your knitting, exploit your comparative advantage. That's what Smith tells us to do. And then from Coase, we have a warning about regulating what we do not yet understand. Often, Coase explains there is a hidden economic logic to business practices about truck bartering and exchange. And we don't fully understand them, but we have a propensity then to label them as anti-competitive. And I'm going to call this the Coasean caution. Now, when you combine Smith and Coase, what you have is antitrust constrained to the pursuit of one objective: maximizing consumer welfare. That's it. And I'm very comfortable using that as a term, if not a slogan, for what Herb talked about: expanded output, lower price, higher quality, more innovation. Now, in Thomas Sowell's taxonomy, this means a constrained vision for antitrust. That's very unpopular in today's enforcement milieu, where we're told, and I'm quoting one person out of this milieu, antitrust is standing by while the economy is concentrating, the elites are getting richer, inequality is growing, and neither the market nor antitrust is working for the people, close quote. Robert Bork, among others, applied the Smithian and the Coasean precepts to antitrust. To my mind, the only mistake Bork made was concluding that a singular application of the consumer welfare standard was the intention of Congress. But Bork was spot on in limiting antitrust to what it could do best and nothing more. His critics claim that he was trying to throttle antitrust enforcement and favor big business. They have it backwards. To combine promoting consumer welfare with a laundry list of protecting small business, redistributing income, protecting the environment, aiding collective bargaining, increasing a nation's happiness index according to behavioral economics, limiting corporate political influence, promoting national champions through industrial policy, and finally addressing privacy concerns. To try and do all that is to betray a commitment of antitrust to the consumer. So in the 6 minutes I have remaining, I'm going to touch on two of the topics where neo-Brandeisians take the wrong path, big tech and labor. Though I would welcome discussing the neo-Brandeisian flirtation with the happiness literature of behavioral economics and its continuing love affair with the protection of small business. Coase would be the first to warn us about the current antitrust attack on what is called big tech and platform markets. The attack on Google is the episode with which I'm the most familiar. So think about this for a moment. After a century of understanding that monopolies charge high prices, we now encounter a firm that offers a search engine, digital roadmaps, flight schedules at zero price. At the elementary level of economics, this seems too good to be true, the opposite of the kind of firm that charges high prices. But we're informed there is a price, the price that we pay for privacy. Google provides information to other firms who would like to tell us about themselves. This can be seen as a price, or at least weighed as a cost against the benefits of all the information we're supplied at zero price. The question I raise is, should we let someone from the world of antitrust mandate that this price is too high for our own good? The Coasean caution counsels against regulating something that we don't fully understand, but which millions and millions of consumers value, and where much of the antitrust objection against Google comes not from consumers, but from its rivals. My colleague Herb Hovenkamp has indirectly endorsed the Coasean concept when it comes to the tech sector. If I may quote Herb, many of the aggressive antitrust actions against the large tech platforms today are wrong-headed. They pursue too many practices that are either harmless or beneficial, and at a cost that sucks resources away from more promising enforcement actions. Now, my 3 minutes about labor and antitrust. So let me stipulate, first of all, that labor policy in the United States protects collective bargaining, but the nation's antitrust policy favors competition. So if you apply Smith and Coase here, it's not very complicated. Labor unions have their sphere of influence. Antitrust should stick to its sphere of helping consumers. So to protect businesses that shoulder high labor costs from lower cost rivals, that's probably going to reduce consumer welfare because consumers are going to pay higher prices for less output. If consumer welfare is really going to be antitrust's North Star, which is what I think it should be, attempts by labor unions to thwart efficiency-enhancing mergers in order to protect wage levels shouldn't be part of antitrust's agenda in assessing mergers. Let me give what my students call a shout out to the recent paper by Jeff Manny and Brian Albrecht on antitrust and labor. To my mind, the relationship between collective bargaining or labor unions and antitrust should be seen as morganatic. It should not be seen as cordial or complementary. I wonder if you've ever wondered, as I have, what caused the rise of the neo-Brandeisian movement. Lazar on my left here and Nicholas have a very interesting paper on this topic. All I'm going to say here in my time limited is the starting point.
You can talk about this all you want.
Okay, all right. A shout out to their paper. It's very, very good. The starting point, I think, is to recognize that this movement is anti-economics. That's the taproot of it. What Herb Hovenkamp has called a reactionary hostility to economics. Now, I've been involved in antitrust consulting and research for a long time, and I make it sure that my students understand that the consumer welfare standard is not like a vending machine. It's not something that just chunks out an answer like in some wooden and mechanical way. It takes a lot of hard work. But the dismal science, econ, is the one area, the one discipline that has guardrails for doing that type of work. The neo-Brandeisian alternative does not. I do admire the rhetorical genius, we can call it slogans in this conference, for the neo-Brandeisians. Even Brandeis' term itself The curse of bigness. That is rhetorical genius. Rhetorical genius, the curse of bigness. I remain grateful for a Supreme Court decision that was, hard for me to believe this, 105 years ago, when the court said in the United States, the law does not make mere size an offense, or the existence of unexerted power an offense. I've been at this for many years, and I reckon antitrust is always going to be vulnerable to mission drift. That's part of what this conference is all about, and I hope the effect of it might be to stop this mission drift. Economists who understand the theory of rent seeking, we shouldn't be surprised that this goes on. Frankly, I remain surprised that antitrust has not been more fully captured by those with contrary axes to grind. And I'll stop at that point, Lazar.
Thank you, Ken.
Did I do it within 8 minutes?
Sure, yeah. So I'm being very reductive. From Herb, I'm getting the sense that the consumer welfare standard is not dead, to answer the slogan question. And from Ken, I'm getting the sense that it shouldn't die in any case, right? So your perspective is a bit more normative. Maybe I want to turn to the other side of the room and to Cani, who's online. And I'd like to give you the chance to also comment on whether you think the consumer welfare standard is dead. I'm going to turn to Cani. Cani, can you hear us?
Hello. Yes, I can hear you.
So I'd like to ask you, in your capacity as president of the Comisión Nacional de Mercados y Competencia, what do you think about the statement that the consumer welfare standard is dead? Are you drifting away from it? How do you feel about this?
We are not drifting. Apologies. We are not drifting away from it, but I think that the discussion is, in my view, and I am answering as an enforcer, so a much more pragmatical and hands-on approach to it. We believe that in order to put it correctly, at least in Europe, and certainly as we apply it in Spain, we would say that we look at the consumer welfare standard not only in a short perspective, but also in a long-term perspective. And by saying so, what I want to convey is that, in fact, for us, we believe that antitrust is there also to protect the competitive process in order to, at the end of the day, protect the consumer welfare standard. So I don't think the discussion, which I understand from an academic point of view, is really interesting, but I'm not sure that it is such a discussion when it comes to apply antitrust rules in order to protect what we have to protect. So what I'm saying is that anything that is under the demand curve and above the market price, anything that is included in the demand curve for us creates consumer welfare, whether it is price, but also, of course, quality, innovation, privacy. So the concept is, and this concept is used by economists across the policy spectrum, not only competition, but also trade and public finance. And we do apply it. So it is, at the end of the day, it is consumer welfare, but we do so by protecting the competitive process. And in that, we give a look to many markets. And if there is a monopsony situation, for example, in a merger that's going to harm the market of labor, we will also give a look to it and see whether it is threatening welfare at the end of the day. So to give you some illustrations of what we've done recently, and taking digital mergers, which is one of the areas in which we have been criticized of under-enforcement. Everybody has been criticized of under-enforcement. I think what we do, for example, is always analyze the impact on innovation. Even though it has not been a decisive theory of harm in innovation in any of our cases. We always give a look to innovation and whether the merger is going to threaten it in a way. We don't measure innovation, but we see the impact that it's going to have and the incentives that parties are going to have in innovation before and after the merger, for example. And why one example in which we explore that intensively is, for example, Norton Avast, if anyone wants to give a look. So we systematically try to grasp whether innovation is relevant in the market, and if it is, which are the efforts of the parties, the relative innovation efforts of the parties involved, the expected impact in the operation and on the aggregate innovation efforts in the market. Measuring it is impossible. I agree with the presentation, but we do give a look to it. Karnov, for example, was another example in which we examine potential horizontal effects on both innovation and quality, because quality is another parameter that we really take into account. And to illustrate a very good example of this, I would quote, for example, one of our recent mergers in the healthcare industry, Quirón Santa Cristina, where we were analyzing the impact of the merger on the quality of healthcare, and in the end, we approve it with remedies in order to mitigate the risk of worsening quality in the provision of certain healthcare services. So to sum up, I don't think the consumer welfare standard is dead. The question is whether we interpret it in the same way, and I can tell you that when we give a look to any practice, whether it is a monopolization practice, a merger that is happening or something, we will be giving a look to consumer welfare, but also taking into account that protecting the competitive process is a way of enhancing consumer welfare at the end of the day.
Thanks a lot, Cani. I'd like to turn to the other two speakers. What do you think about the two slogans that we've discussed, or any others that flow from Herb's and Ken's presentation?
Okay, I would like to move away from the US, really, and talk about the rest of the world a little bit, but also talk from a perspective of somebody who's had some judicial experience, because I'm a bit baffled by the discussion on the consumer welfare standard. My reaction is first to say that if we are going to have any kind of repressive law of that type, there are three things that have to be related. One is the goals that one tries to pursue. The next, of course, is the standard, which is going to decide what is illegal and what is not. And third, it's the test that is going to actually be used to find out in which cases we are. So what I'm saying is that we cannot think about the test without thinking about what the standard is, and we cannot think about the standard without knowing what the goal is. Well, outside of the US, it seems to me that the goals of competition law are not very clear. And if I take even the European system, if I take the European debate, Mario Monti in 2001 certainly very clearly said the goals of competition policy in all of its aspects is to protect consumer welfare. Then he had a string of defeats in the courts, and then we have other opinions. Certainly Wouter Wils and Jan Cocotte, for example, don't agree with this, and they say, look at the treaty. I don't see consumer welfare written anywhere. So it cannot be that this is the goal of the law. The goal of the law is to push towards the single market, and so it's the market integration, which is the goal of the competition law. Now, if that is the case, of course, we should have a different standard than if the goal of competition law is the pursuit of consumer welfare. And then we have Ariel Ezraki, who says, I don't know what the goals are, but I'm going to look at the decisions of the Court of Justice to try to reconstruct what it is that they think is the goal of the law. And he comes up with consumer well-being, effective competitive structure, fairness, efficiency and innovation, plurality and economic freedom, and market integration. So it depends on the decision, but different goals. Okay. So first point, we should have a discussion on what the goals are before we have a discussion on whether consumer welfare is. Second thing is, once you understand what the goal is, what does one expect from a standard? And when you look at least at the legal literature, you expect a lot of things from the standards. I mean, it's a multidimensional thing. You expect the standard to be clear and precise, to be consistent, to be fair and equitable, to be relevant, to be enforceable, to be adaptable, to be transparent, to be accessible, et cetera, et cetera. Okay, so if we're going to discuss the consumer welfare, we have to discuss the standard consumer welfare along all those dimensions. And on some dimensions, of course, it's doing very well. For example, it's fairly clear and precise, okay. Whether it's relevant or not, I don't know, because for this, I should know what the goal is of the competition law, and I'm not sure what it is. Whether it's enforceable, that's probably where the largest weakness is, because a lot of the discussion that we've had in Europe is that too much economics is necessary. It becomes too complicated for the parties, but also for the courts to interpret. But on the transparency, accessibility is doing very well. So I think that one should not have a judgment which is on one dimension. One should look at a standard that would, given all the dimensions of the standard, be the most satisfactory. Now, I noticed that there's no real alternative standard that I've heard about, which fills all those categories and which seems to be clearly superior to the standard. The last point is, however, we have two weaknesses. One of them I've already mentioned, enforceability. Okay, it's quite difficult to use. But the second one is that there are a number of studies which take the narrow interpretation of the consumer welfare and say, in merger decisions, do we see that prices go up after the mergers have been allowed by the competition authorities? And I'm not going to go through all the literature, but there are a number of studies in different countries, in the US as well as in Europe, saying, well, in particular cases, indeed, the prices went up, which in principle is not what you would expect if the consumer standard had been properly applied. So there may be a question there of whether this standard, to the extent that it is used in a sufficiently consistent way by competition authorities.
Right. I want to touch on something that you said, which is one of the alternative goals of antitrust law that is mentioned often. So some say the purpose of antitrust law is to combat economic concentration, and that it is this principle which should guide antitrust enforcement. As somebody said, the guiding star, the North Star of antitrust. This seems to put the consumer welfare standard in a secondary position, as maximizing consumer welfare may or may not overlap with that goal. So I want to turn to Dennis for a second. What do you think about this statement, slogan, or substance?
Well, I kind of agree with the previous panelists, especially what Fred just said about being perplexed sometimes by these recent discussions. My sense is it's pretty clear as an economist, what we want from the antitrust laws. I would call it, we want to maximize total surplus. Herbert said, and I agree, that's lowering price, increasing output, improving innovation if you can. Those all make sense. Which one you call it, I don't really care. What bothers me is when we go to other objectives, either structural presumptions. I want a market share below X, which means I got to define market, which is a very crude tool to use, rather than looking what has happened in the past from mergers in this industry. Right. So to follow up on something that was just said, if you've done retrospective studies in this industry, you have a pretty good base. I don't need to fool around with all this market definition stuff, it seems to me, if I say, look at what's happened in this industry over time. Mm-hmm. Prices have gone up. Boy, maybe this isn't such a great idea. I wouldn't have allowed a merger, at least when I was at the Justice Department, I wouldn't have allowed a merger in which prices are going up. I'd scratch my head if that had been happening, and I'd say I better do something different. I think the FTC's studies of hospital mergers led to a change in how hospital mergers were treated, and that's exactly what an economist wants to do. Look at the evidence, what has happened. De-emphasis on structural presumptions. So what bothers me about what's been going on, especially in the last administration, is this attempt to say the consumer welfare standard, that's something economists, these nerdy economists might like. But we are much broader. We're interested in a whole bunch of things: income inequality, preserving small business, saving the environment, employment, and then this is a word that makes me, as an economist, nervous: fairness. Anyone who's been a parent knows, and you speak to your children, any decision can be unfair if it's not favoring that child. So my view is if you want to turn antitrust into something with multiple objectives, other than a clear objective, which I think Herb went through, our antitrust laws are pretty clear on what some of the objectives are, what the main objective is. You start mucking it up with all these other goals, you will wind up in a situation where I think you will achieve nothing. You will achieve uncertainty. You will delegate discretion to courts to do basically whatever they feel like, because there are no standards for figuring out how do you trade off all these different properties. I view what has happened last 4 years as an attempt to diminish the role of economists compared to other methods of litigation, which lawyers are better at. You know, Joe said this, isn't that terrible? Well, the economists would say, I don't know what Joe, speak to Joe. Here's what has actually happened in the marketplace. When they talk about, one argument that's often used is, economists are talking about consumer surplus. Now, Bork really used total surplus. But when he uses total surplus, that's been criticized for saying, you see, you care about firms. Well, there's been no question when, for example, say, you don't care what's happening to labor. That's not true. That's not true at all. I don't think there's any economist, or perhaps any antitrust lawyer, though they can speak for themselves, that would say that a cartel of buyers that would allow workers to be exploited, monopsonized, that couldn't be actionable under the antitrust laws. So I agree with that, but with what's been, that push to apply the antitrust laws to those situations. That is not a refutation of the total surplus standard or the consumer surplus standard. When I was at the Justice Department, I said, I want someone to find me a case where maximizing consumer welfare, just focusing on consumers, is different than maximizing total surplus. There was one maybe example out of that they could find. I think this is a made-up distinction used for debating purposes to denigrate the economic analysis of antitrust cases and to give more discretion to policymakers to pursue whatever politically popular policies they want to pursue. So it's very dangerous.
Right. I want to discuss process, but
Okay.
if you can, yeah.
Just two comments on what Dennis just said. First of all, he said very clearly, economists have a view of what antitrust should be like. Fine, I agree with this, and I agree with the view that he has. Question is whether they have a legitimate interest or legitimacy to impose their view on the judicial process. Second thing you said, which I slightly disagree with, coming from a European experience, you said if it was not the consumer welfare, then it would be open to the arbitrariness of the judicial process. If you actually believe that the European competition law has only one objective, which is the achievement of the single market, it very clearly tells you you have to be tough on vertical restraints, because that's one of the ways in which you can prevent the. So it is not a recipe for saying you can say anything. It's a recipe for saying things which may not make sense from an economic point of view, but that's
I
not
agree with that.
Okay.
Yeah. Some disagreement at the margins, but as we learned earlier, that's where the real agreement and disagreement happens. I'd like to discuss.
Can I add something here?
Yes, briefly.
Price output and innovation are solid as metrics. That does not mean that measurement is easy. It can be in some cases. You can look at a cartel and do a before and after test and estimate. Estimating the price and output consequences of mergers that haven't occurred yet is actually a pretty hard thing to do. And we do a lot of retrospective studies. Dennis notes solid evidence that mergers with similar structure characteristics have different behaviors in different markets and so on. And, these are fact questions, they're empirical, they justify modifying the guidelines from time to time as things get better. But, that doesn't mean there's something wrong with the metrics. It simply means that in certain settings, and particularly, I think that is the most difficult one faced in the US, is how to predict the consequences of a merger that has not yet occurred. That's a hard thing to do no matter what standard you adopt.
That's a perfect segue into the next slogan or statement, which is that the consumer welfare standard is slanted against enforcement, and that it, by design, leads to under-enforcement of antitrust laws. This implies that an increase in the levels of antitrust enforcement, if this is what we want to pursue, is only possible if you move away from the consumer welfare standard. Another implication is that the consumer welfare standard sets the bar too high for plaintiffs, so the burden of proof should be reversed in many cases. I open up this statement or slogan to the whole panel, whoever wants to start, whoever has thoughts. Cani, that also includes you, of course.
Well, I'll simply
Okay,
say
thank
that,
you very much. I can start with this if you want, but I will be very brief because, in fact, I think that this is a statement that comes from a wrong interpretation of what is consumer welfare standard. And as we've seen in the panel already, consumer welfare standard is not excluding from its range the analysis of parameters like quality or, as, for example, Dennis was saying, and I fully agree with him, that was also I referred to in my previous intervention. If we experience a problem with labor, because there are anti-competitive practices touching labor, of course, labor is going to be one of the parameters that we are going to analyze, and whether there is a restriction on that. So it depends on how you are going to interpret it. But I absolutely believe that antitrust should not include goals as sustainability, industrial policy, labor rights, or any diffuse political power. That's not the goal of antitrust. But the proper interpretation of the consumer welfare standard is going to include many of the things that have been claimed not to be taken care of. So I oppose the idea that there has been under-enforcement. At least in Spain, I can tell you that it has not been the case. Maybe also because in merger control, we have this market share threshold of 30%, and most of the criticisms of under-enforcement comes from the merger control perspective. So, yeah, that's my input to you in this slogan. Yeah.
Thank you, Cani. Ken wants to say something.
I'd like to respond to the notion that the consumer welfare standard is biased against antitrust enforcement. I don't think that's true at all. It simply sets up guardrails as to what the objectives of antitrust enforcement ought to be, and that's protecting the consumer. A number of us can speak to the American political scene. We've worked at the Antitrust Division, and we look around the federal government and we think, are there any other friends of the consumer here? When I was at Justice Department, I couldn't find any friends for the consumer at the Department of Labor. I couldn't find any at the Department of Commerce. But the only person I found that was friendly to the objective of antitrust protecting consumers were some people over at the Council of Economic Advisors, people like Sam Peltzman and so on. But it seemed like the whole array, Department of Agriculture, there were no friends of consumers there. Is it too much to ask to have antitrust be the one agency that's friendly towards consumers and considers that as its main objective, given all the other agencies that are engaged in hostility actions that affect what people pay? Antitrust Division has a wonderful objective of helping consumers get high quality products at low prices. Why would we want to attack that or add something to that that would diminish the benefit that we offer to consumers? There's all other kinds of agencies that are trying to help the farmers and small business and so on. If we want to help small business in the United States, antitrust is not the way to do it. I remember Don Baker saying that the one social benefit of the Robinson-Patman Act, which for those of you from Europe was designed to protect small business, it had two things you could say in favor of it. One is it provided a full employment act for antitrust lawyers. And number two, it provided laughingstock material when you taught antitrust, because students found it so ludicrous to look at the complexities and confusion of the decisions in the Robinson-Patman Act. So we largely got rid of that. Imagine how distressing it is to see it coming back now. I mean, it's just, wow, that's really sad from the standpoint of consumers. Helpful for small business, but we have a small business administration in the United States. Let them do that. They could do a much better job than they do now by just getting rid of a lot of the regulations that hamper small business in the United States. Get rid of the patent trolls that affect them. That would help. Taxation can help, but not protecting them against price competition. That harms consumers.
But we're hearing that digital markets are fundamentally different. They require either a new standard or an overhaul of the existing one, or a lowering of the burden of proof, or even a reversal of the burden of proof. So this is a question for everyone. Maybe we can start with Herb.
I think that one of the most important things antitrust can accomplish in the next few years is to integrate digital and offline markets.
Switching the burden.
They're very different from each other. There are some products like streaming and e-books and so on that very likely the digital version is the search, right? Paper search. I remember paper search from when I went to law school, but it's never going to compete with digital search. So search is going to be a purely digital product. There's other products like massages and oil changes and window washings. You might be able to schedule them online, but the product has to be delivered offline. And then there's this big array of products in the middle, screwdrivers, toasters, socks, shoes, and so on, where what do you find? Well, you find a competitively structured digital market for, say, screwdrivers, a competitively structured offline market. Well, that tells you there's no cellophane fallacy, that both sides are competitive. And then you see people going back and forth, shopping one to another, and that tells you there is one market for those products. It's either offline, I mean, the offline and online portions are the same thing. And so this question of market scope, what extent it includes both offline and online sales, is extremely product specific, just like all questions about relevant market, and that's the way they should be addressed. So, for example, one of my problems with the Digital Markets Act and our equivalent, the AICOA in the US, is it singles out digital markets for close scrutiny without any real justification. If self-preferencing is a bad thing for Amazon, well, why is it not a bad thing for Walmart?
Right.
Which makes all kinds of selections about where on the shelf things go. We have to look at these things together, not simply isolate digital markets.
Especially if it's unfair. If it's unfair, then it should be unfair in other contexts, right?
Yeah.
Fred, you wanted to talk about the reversal of the burden of proof.
Yes, at least in Europe, I think it's quite an important topic. I'm talking here about mostly legal presumptions, and in particular, objects violations. They do two things. Not only do they shift the burden of proof, but they also prevent you from presenting some argument in defense. Okay. Now, there are good reasons and there are bad reasons to have legal presumptions. Among the good reasons or tolerable reasons, I would say, because in all cases it's a shortcut. But tolerable reasons are when the presumptions are based on experience, jurisprudence, for example, when something has been systematically found to be a violation of the law. It's okay to presume that it is a violation of the law. Or economic analysis. There's a big debate in Europe between, it used to be between Niels Wall and Julien Cocotte, on what is the relative weight of the economic evidence as a basis for presumption, and what is the relative weight of the jurisprudence. So there may be another reason which could be proof proximity, which is the fact that some people have access, some parties have access to information that either the court or the other parties don't have access to. So in that case, one can understand that it reduces the cost of enforcement. And there is something which I think is quite a bad reason, but which is very much pushed by the European Commission, is what they call effectiveness, the fact that at some point they decide that they want to increase the effectiveness and enforcement, so therefore they're going to create the presumption so that to simplify. And there are two reasons why I think that this is a very dangerous precedent. One of them is, first of all, if you really want to prioritize those cases, you don't have to create a presumption. I mean, you can just put more resources going after this, so there's no need for this. But the second is the fact that for policy reason, you might create presumptions which go against either the experience or the proof proximity principles. So you may have inconsistency in your presumption. Now, this is a real important issue. The Court of Justice has, after allowing a lot of object violation, has decided that now it wants to ask from the competition authority, from the commission, why it is that a presumption is justified, which is one way to restrict the scope of this. But shifting the burden of proof is not something that you do just to make life simpler for competition authorities, or it shouldn't be.
We've been putting the consumer welfare standard on trial, but we need a standard by which to judge a standard. So I'm interested in hearing from the differences between the lawyers and the economists on if you could sum up in 2 words what the 2 most basic traits of a standard should be. What makes a good standard in 2 words? Maybe we can start from here, finish with Cani.
States a clear goal and provides metrics for assessing it.
Goals and metrics.
Yeah, I would just add really something complementary to what Herb said, and that is economics is, I think, a discipline pretty well suited in terms of our training to put some numbers on these metrics, particularly
Just 2 words.
output. Oh, all right, all right.
We'll discuss it
it
at
would
lunch.
be output and low price.
Output, low price. Okay, works.
Relevant and enforceable.
Okay.
I liked Herb's 2 suggestions, but I would add a third. Make retrospective studies of what you've done and why you've done it. Part of the record of the enforcement agency to understand what's motivating, what model did they use? Did they use an economist? Or they just rely on, what Joe said to stop the merger or to allow it? Was that good? Was that bad? Which economic models did they use? What assumptions? We say economic models. Economic models are based on assumptions. What were the good assumptions? What are the bad assumptions?
So retrospection, maybe?
Retrospection, and this really goes to presumptions, okay? Because it's easy for people to say, gee, you allowed that merger and price went up.
Okay.
But they don't say, you allowed 50 mergers and price went down.
Okay.
So there's nothing about looking in the past at what you've done that is embodied in what our, at least in the United States, what our agencies are required to do. And that would help a lot for understanding how practice could be improved.
Okay, so retrospection or maybe hindsight. Cani.
Okay, so I would say that what Dennis was trying to say was impact assessment, which is something that competition authorities are more and more trying to do. And if I had to add, in fact, it would not be 2 words, but 3, which would be correct error cost framework. So the rights costs of type 1, type 2, but I mean, try to see whether the presumptions are really answering to this framework.
Okay, makes sense. Thank you.
Thank you to our panel. I only have one word for you: lunch.